Hello, this is Dr. Schamberger, and in this talk we will focus on open meetings and open records laws in Kentucky, also known as sunshine laws. This is one of my favorite areas to discuss, and I will share with you why. My background in open records laws and open meetings laws started when I was a graduate student at Murray State University. So in the early 2000s, I was really wanting to pursue a project that matched my interest. At the time that I was a graduate student, I was a news reporter at the Kentucky New Era daily newspaper in Hopkinsville. And I had observed some problems with some the public officials' knowledge in how they interpreted and how they used open meetings as well as open records laws. So it helped me to lead to my graduate study, Is the Door Open or Shut? A survey of elected officials. In addition to the study, the Kentucky New Era worked with me to publish some of the results, and we worked up news stories along those same lines. And those news stories were recognized with awards by the Kentucky Press Association. My interest did not stop there. When I decided to pursue a doctoral degree, I wanted to focus on how well students were being educated on sunshine laws. So that led me to my dissertation, The Presence of Sunshine Laws in Journalism Curriculum, Qualitative Insights. This focused on the laws in Tennessee. During the time that I was a doctoral student, the laws in Tennessee were undergoing some major overhaul changes. So I wanted to see what the instruction in college classrooms, how that was being reflected as a result of the changes to the laws. Surprisingly, in a way, and then to some extent not surprisingly, but really overall the results showed that the curriculum changes were not keeping pace with the changes in the laws. From this dissertation, I was able to work up two different articles that were published in peer-reviewed journals. One is the Sun Shining, a qualitative study on the presence of sunshine laws in the college and university journalism curriculum. That one first, that one was published in the Journalism and Mass Communication Educator. Even though it was first published online in November 2015, it finally went into print in the spring 2017 edition. And then teaching transparency, a one-state case study of sunshine laws in the journalism curriculum. That one was published in Teaching Journalism and Mass Communication Journal in summer 2015. So my plans now, as far as sunshine laws, it's still one of my research interests, and I next will focus on Kentucky. Every year in the Kentucky General Assembly, bills are proposed as to how we can either strengthen those laws, and then some lawmakers also will propose measures to somehow make the laws less stringent for public agencies, which can lead to problems for citizens and for us as journalists. So I've been saying sunshine laws quite a bit, but these laws also go by other names. Sometimes they're known as just open government laws. They might be referred to as Freedom of Information, and that's really the federal act, the Freedom of Information Act. But some states will also recognize it as Freedom of Information. Open access, access to information laws, and then perhaps one of the new buzzwords when describing sunshine laws is related to the concept of transparency. However, no matter the word or phrase, every state has a law on the books. And one of your responsibilities as a journalist is to know what your state, so if you decided to move away from Kentucky and go to another state to work at a news organization there, you need to know what that state's sunshine laws are and what they spell out. There are two purposes for open meetings and open records laws. First of all, the reason why they are called sunshine laws, because if you think about what sunshine does, it lets in the light. It opens up a room. So we want to conduct the public's business in the open. We can't have it in the dark. And the reason why is because the public has to be a part of the policy-making process. In order for us to report to the public what is going on, we have to be there. And that's why covering meetings is so important. So that way, first of all, we can make sure that the public's business is being conducted properly and ethically. And then second of all, to make sure that the public is aware of what's happening. So that way, if individuals decide they want to be a part of a solution or be a part of the discussion and the discourse, they have the knowledge to navigate through all of that. This is a cartoon that I really enjoy, an editorial cartoon that really, I think, illustrates accurately what the climate is regarding sunshine laws, especially among politicians. So you have backroom politics that often go on, and then you have politics. So the sunshine laws have to make sure that these two dark clouds do not combine and strengthen. So that's why it's really important to have sunshine laws. So that way we can keep all the backroom discussions, secrets, um, hidden material. We don't want that to be hiding. We don't need that to be in the dark. Politics should be done in the open, and anything dealing with public business should be done in the open. It seems like an easy thing to do, just follow what the Sunshine Law says. However, there are problems and the reasons why these laws are not being followed to the T. One of the big reasons that came out of my comprehensive study from Murray State was that there is a lack of training for public officials. Many times in Kentucky, for instance, school board members, they're just given a copy of the laws and all they have to do is sign off that they received a copy. There really might not be any training involved. Or if there is discussion, it's glazed over quickly. So that way, public officials, and a lot of them are told, you don't have to worry about this. You let the attorney take care of this kinds of stuff, or you let the superintendent take care of it, or the principal, or whatever. So our elected officials and most public officials just don't see it as necessary. In addition, there are mixed interpretations. And you will find that in looking at some of the sections of the law closely that it can have some varied meanings for various groups. There's also this sense that council members or board members don't want to be bothered with this. And that's because a lot of them are just thrown into a position and all that they see that their role to be is nothing than maybe just a stamp of approval type process. So any of these technicalities on how to run a meeting, an open meeting properly, or how to respond to open records request, even if they were to receive such a request or a complaint, they're just going to turn it over to an attorney anyway. And that leads me to my next point. So the attorney often is trusted with these issues. However, you got to remember the attorney is working for the council or the board. So that attorney is going to do what he or she feels is in the best interest for for the council or the board. And that interest could be simply that I don't need to be bothering this body of officials with this request or this complaint. News media also don't do their good job. They don't do a good enough job of trying to challenge public officials. So if you're covering a meeting and you notice something that's not right, that possibly a violation occurred, you need to act on it or you need to study it and decide quickly, should there be some sort of recourse for that? Should I file a complaint? Likewise, if you keep hearing about a certain public record but you haven't been given a copy or you just want to know more about it, you need to file an open records request. So we've got to be able to do our jobs better. These sunshine laws are our tools for the way we gather news and the way we report news. So for us, they're really important. These laws also are important for citizens. And you should know that these laws are not media laws. They're for everybody. But for us as journalists, we have a greater advantage because, again, like I said, these are news gathering laws for us and these are reporting laws for us. So that way we know we get the information as best as possible when we can use the law as our vehicle to gain that information. Journalists often like to observe Sunshine Week, and during that week, you might see stories that sometimes I know the Associated Press likes to do, maybe a community organization will do something, and then sometimes various reporting groups will organize certain events and topics. So, Sunshine Week is celebrated every year, and in 2018, it's March 11th through the 17th. It always carries the theme Sunshine Week, Your Right to Know, because that's really what we're trying to educate citizens and each other about. The American Society of News Editors and the Reporters Committee for Freedom of the Press coordinate these activities, and they also do a lot of coordination of content on the website, sunshineweek.rcfp.org. I encourage you to visit it. It's got material from last year's Sunshine Week as well as the dates for the 2018. So let's go ahead and dive in and see what the Kentucky Sunshine Laws include and who must follow these laws. First, you do need to know that the Open Meetings Act is spelled out in Kentucky Revised Statutes, so KRS 61.805, all the way to 61.850. So if you need to look up something specific, you can go to that specific statute in the KRS section of the Kentucky Open Meetings Act. The Open Records Act has the KRS codes of 61.870 to 61.884. Now, you might not need to know the exact numbers, however, you really just need to know where you can find certain pieces of the law in case you need to use those as your ammunition in certain arguments. Kentucky Sunshine Laws must be followed by any agency that receives at least 25% of the funding from state or local public sources. So if a certain agency gets 25% of its funding from, say, the city government, then that agency has to follow the Open Meetings Act and the Open Records Act accordingly. These laws apply to any state or any local entity that serves the citizenry in any way. And this can include committees that are created by public agencies. So for instance, a city council often has committees that will focus on public works, or committees that also focus on budget. Those committees must follow the Sunshine Laws in Kentucky. So here are some examples of various governing agencies that definitely have to follow these laws. School boards, because school boards receive almost all of its funding from tax revenue sources as well as state revenue sources. School-based decision-making councils have to follow the Sunshine Laws. City councils, any type of municipal corporation, any advisory committees that might be established, even subcommittees, as I noted earlier. Also ad hoc committees that, again, are of agencies and interagency bodies, and at times these can pop up when they're trying to coordinate activities for a certain solution. Either way, if that committee originates from a body that receives at least 25% of funding from state or local public sources, that committee has to follow the laws too. With an Open Meetings Act, we're going to start and focus on that one first. So first of all, at any public meeting, a quorum has to be obvious, and that is needed to make any decisions. Meetings that have less than a quorum of the agency's members are to be open, so they can still have a meeting, they just cannot make any decisions. Agencies have to make a schedule of regular meetings available to the public. Each year, various public agencies such as school boards will approve a meeting schedule. And when that meeting schedule is approved, then they will post that meeting schedule somewhere, maybe on a website, for instance. Also, in addition, when maybe about a week or so before the meeting, they have to be able to have that meeting information posted somewhere. That can be on the door, that can be, it's also published in a newspaper, and we'll talk more about that. But they have to make it public. Now, those are just regular meetings. There's also special meetings that are outlined in the Open Meetings Act. Special meetings might occur. However, an agency has to give notice in writing to the publication, to the main publication of the city or county in which that board operates. And this notice has to include the date of the meeting, the time where the meeting's going, when the meeting will occur, the place of the meeting, as well as an agenda. On that agenda, the members can only discuss and act those items at the meeting, and it's only limited to those items on the agenda. Notice has to be given at least 24 hours in advance by hand delivery, maybe even by fax or mail, and now even email. So that's also a possibility. And like I said, too, uh, all meeting announcements have to be posted at the meeting place and at agency headquarters, but the same holds true for a notice regarding a special meeting. Every public issue that is on the agenda is open to public discussion. Now, public agencies can enter into closed session for these three reasons identified here. One is that they can go into closed session to discuss what we would call property acquisition. So, really, that's deliberations on future sale or purchase of real property when the publicity would probably affect the value. That is protected under the Open Meetings Act for public agencies. They can also go into closed session for the purpose of discussing proposed or pending litigation. So if a public agency is named party to a lawsuit, then whether they're filing one or whether they are named to one, they can go into closed session to discuss that particular piece of litigation. They also can go into closed session for specific personnel issues, not general, specific personnel issues. In other words, they can only discuss a certain individual. And even with that, that's usually regarding the discipline or hiring or firing of an employee. So it's not like they can just go into closed session to discuss just anybody. It has to follow one of those three reasons: the discipline, the hiring, or firing of someone. And it cannot be general personnel issues such as salaries. So they cannot go into closed session to discuss salaries for everybody. That's not the way that works. To go into closed session, someone has to make a motion, and then the board or the council has to vote on it. No final action can be taken in private. That means they can only discuss in closed session one of these three things or more than one of these three things, but they cannot decide on anything in closed session. Any decisions have to be made outside of closed session. So what they'll do is they'll go into closed session to discuss one or more of these items identified that they can enter into closed session. They'll discuss. And then when they feel that the discussion is sufficient, they then come back into open session, and a vote has to be taken that they will re-enter into open session. And then during the open session, if there are any motions or anything to be made, that's when they do it, is in the open session. So what do you, the journalists, do when a closed session is ongoing? Sometimes closed meetings can go on for as short as, I've seen closed meetings occur 10 minutes. I've seen closed meetings to last as long as 2 hours, and I've seen them last even longer than that. So what do? Well, really, you do have to stay at the meeting. You can't just leave when they decide to go into closed session. You have to be able to stay outside the closed meeting walls. Why? Well, when they get ready to go back into open session, and if they vote on something, that could be the news story. Second of all, what you should be doing, if at all possible, and for some people, a lot of people find this to be unethical, but at any moment you can, when maybe you're not being watched, but just kind of put your ear to the door to hear maybe what could be the item being discussed. You can't use that material in your news story, but it gives you kind of an advantage. You can at least figure out what they are discussing, and then you can find other ways to corroborate that information through interviews, more research, more digging, etc. And then plus two, it gives you the opportunity to think, are they really talking about what they should be talking about? So sometimes it just helps to keep everything in check. Will you always be able to kind of eavesdrop? No, it just depends on the quality of the sound and things like that. There are times when I'm not able to hear because maybe the door is really thick or the walls are thick, or maybe the distance in the room is too much, so they're not anywhere nearby an opening where I could hear. But you should just be able to do a number of things. In addition, so let's say that you've kind of listened to all you can, or it's listening is not a possibility, then you can start working on a story. So I mean, it's not time being wasted. You have to be able to make use of that time, and so that way you can go ahead and maybe tweet updates, or you can work on the first part of your news story. You can talk to your news editor by phone, whatever you need to do, but you do not leave the meeting when they are in closed session. There are times when members of a board are not recognizing the fact they are going to close session illegally. Remember, a lot of the training of these board members is insufficient, and the attorney doesn't always do his or her job properly either. So if you think that the members are going into closed session illegally, it's up to you to stand up and say so. But be nice about it. We're not trying to be any type of confrontational beings, but we do need to be able to stand up and just have some clarification as to really, can they go into closed session for that reason that they noted. You can request, so let's say that they just say they're going into closed session. Well, then it's up to you to say, "Excuse me, Madam Chair, or Mr. Chair. I request that you follow the Open Meetings Act and specify the reason why the City Council is going into closed session, and ask them to cite the specific KRS piece that allows them to do so." But you've got to be able to do that. You cannot be afraid to stand up and make that challenge. All right, with the Open Records Act, this is another good tool for us to use when we're trying to gather information for news stories. So what is an open record? In Kentucky, an open record is a number of materials: books, papers, maps, photographs, cards, tapes, discs or diskettes. So that's kind of showing the age of these laws a little bit, but it has been revised since, or excuse me, over time to include software, recordings, or other documentation, regardless of physical form or characteristics, that are prepared, owned, used, in the possession of, or retained by a public agency. Now, the document, or the record, I should say, the record has to exist already. Public agencies are not required to create records for you. The record has to already exist. So they don't have to create, for instance, an Excel spreadsheet. That's not within the parameters of their duties, and that's not within the spirit of this law either. So you can only ask for what exists. Now, any records of a private company that are not related to state or locally funded operations are not public. And this is where sometimes it gets a little messy. And this is where it's also good to work with the news organization's attorney. Every news organization will have some sort of attorney who is well versed in these laws and knows what can be obtained and what can't. So if you are wanting records of a private company that you know for sure does business with, say, city council, or does business with some other locally funded operation, then you might want to double check to make sure that an open records request can be created and hopefully fulfilled. When we are writing open records request, we are making that request to the person who is called the custodian of records. That can be anybody. So it's any employee who is responsible for maintaining, for carrying, and keeping the public records. It could be somebody as, say, for instance, even a secretary. It could also be a superintendent. It can be an attorney. You have to find out who the official custodian of records is. And it's just a simple question to ask. Many times when I file open records request on the school district level, I just send it straight to the superintendent, even though I know that person is going to then forward it to the school board attorney. But I do at least send it to him because officially he is the custodian of all records in the school system. There are times when really you don't have to write an open records request. Especially if you have a good working relationship with certain public officials. For instance, I have a good working relationship with school superintendents. So sometimes a verbal request will do, but sometimes I also like to use a written open records request because then I've created a paper trail. And I use those especially in times when I feel that the record I'm looking for or that I'm wanting, I might be challenged by the school board attorney with. So then that's where I think maybe a written request might be helpful. But that's up to maybe you and your news editor to figure out, could this be obtained by just calling to ask, can you get it? Or is it best to write an open records request? Many agencies do require a written request because they want to be able to keep a paper trail themselves. So just kind of know what the quality of the relationship is that you have with the public officials, and then just maybe you want to try a verbal request before deciding to have to maybe do a paper one. Sometimes you can just go in and review the records as well, and if you do so, that's done during regular business hours. If you request a copy of certain documents, the agency can mail you a copy if they're going to charge you fees and mailing costs. Some agencies will, some will not. It depends on the record. Some documents might be, I don't know, it could be anywhere between 50 to 100 pages, and they might want you to pay for those copies, and rightfully so. Um, in addition, if you are located outside the county where the records are maintained, the agency can mail you a copy. If you precisely describe the records you want, the agency is going to be able to mail you a copy or maybe even email it if it's possible. And the requested records are available within the agency. So you've got to know, where are records being stored? Is this, for instance, if you're wanting something with the fiscal court, but you're asking a city office to supply you with that record, that's not going to be possible. So you can only ask for a record that you know exists within that agency. Sometimes, and this has happened to me before too, you send an open records request to someone who is not the custodian of the record. And if that happens, then under this law, that person has to give you the name and the location of the person who is responsible for handling that open records request. In addition, if the record you want is in use by someone else, or if it's just not immediately available, maybe somebody else in the office has it, then the custodian of that record must tell you that and then set up an appointment for you within those 3 days of receiving your request, or give you a detailed explanation of the delay and when that record will be available for inspection. Sometimes, too, I've had it where the school district secretary will call me and say, is it possible that we could get that record to you 2 days after the 3-day mark? And that's fine. We're just trying to comply with the spirit of the law. In many cases, that works well for me. So, again, these are not to be designed to be confrontational instances here. It is a working relationship that you want with your gatekeepers as well as with your sources. So sometimes it's just a matter of just a telephone call that the records custodian will make to determine if they can get that record to you late because it's just somewhere else or something. Now, there are exceptions as to what defines a public record. So there are exceptions that agencies can use where they don't have to give you a record whatsoever. For instance, if it's a personal record that's going to invade someone's privacy, confidential records that are compiled or maintained for scientific research, those do not have to be given to you at all. In fact, those are protected under the Open Records Act. Any documents that are submitted in connection with any type of loans, regulation of a commercial enterprise, a grant, or a review of a business license, that does not have to be released to you. Documents regarding prospective location of a business or property acquisition by a public agency. Again, while under the Open Meetings Act, while public agencies can go into closed session to discuss property acquisition, the documents, they do not have to release those because it might impact the sale of that. So those are not open records. Any academic tests or exams for licenses are not protected under the Open Records Act. So in that public agencies do not have to release that to you. Any type of law enforcement investigation before it's concluded, those are not privy to open inspection. Sometimes if you have a request that might be not necessarily convoluted, but if it's intermingled among materials that you request, especially like open records and some of the records that are closed, the custodian of those records have to separate the materials and allow you to see only those that are open. So in other words, they cannot deny you the full request. If they say, well, we can show you this because the Open Records Act says I have to show you this, but this is not open for public inspection because this record is dealing with confidential information of an individual, then they can do it that way, but they cannot blanket the entire request with a rejection. They have to be able to separate the materials, what they can show you and what they cannot show you. As I noted earlier, records custodians cannot create a record. Again, so that's why you have to know which records are available, and that's just sometimes a conversation with your source. In what format is it? Is it only available as an electronic form, or is there a paper copy? You want to make your request as precise as possible, but you don't want to make it too precise to where it's limiting. And that's why when you write these requests, it's best to have your news editor examine it. It's also a good idea to have maybe even the news organization attorney review it too, just to make sure that everything should be okay. So many times when you think a violation occurs, you've got to go with that gut feeling first of all. But then the process occurs to where we have to file paperwork as a result. So the first step in handling sunshine violations, regarding of whether it's an open meetings violation or an open records violation, it does not matter. The first step is to put in writing to the presiding officer of that public agency. So whether it's a mayor or a board chairman, you just got to figure out which person is the responsible recipient for the violation. And you have to cite the alleged violation in that KRS number and code there. So, and then you also need to state what you think can be done to remedy the situation. So let's say it's an open meetings violation that, let's say that you feel that the board did not follow the law as far as going into closed session properly. So you might offer a remedy, a possible remedy, that any action taken after the closed session, so when they came back into open session, and let's say they took some action, and you could ask that that particular action be considered null and void, and that part of the meeting be reconducted, so that way it's done on a clear basis. There are a number of other possibilities you could offer as situation remedies. It could be something as simple also as that board members be trained properly, and that maybe you lead a session on training public officials, or that you have that their attorney and your news organization's attorney does something to work better for future reference. The agency has 3 working days after receiving your complaint to respond. If they don't respond within that 3-day mark, then you can go ahead and take it to the Attorney General for an opinion there. But they have 3 working days to respond. If the person denies the charge, that person has to cite the specific statute that supports their ability to deny it. And they also have to explain how the statute allows them to do that particular piece of action. So after all that goes through, if that doesn't satisfy you, then you have to send a copy of your written complaint, the agency's written denial, and then your explanation of the situation to the state's attorney general within 60 days of the denial. If the agency did not respond at all, so like I said, you can just go ahead and send a copy of your complaint and an explanation to the AG office. And then the AG has to give a decision in writing within 10 working days. So they do have attorney generals at the state office on staff. They have several who handle certain things. You'll have an AG who is well versed in sunshine laws and handles these types of complaints and violations. So that person responds well to those. And then the third step, either you or the agency then can appeal the AG's decision through the circuit court. So if the decision comes back that you like, it's in your news organization's favor, but the public agency doesn't like it, then that public agency can file an appeal, and then vice versa. If there is no appeal at all, in fact, if let's say that the decision, or excuse me, that the opinion of the Attorney General favors you, and the public body decides not to appeal it, then the AG decision has the same force and effect of law, and it is enforceable in circuit court. And the circuit court could avoid actions that were taken during a violation. So we're going to look through an example in which a lot of these steps were ongoing in a certain case in just a few moments. You also can go directly to the circuit court within 60 days of the agency's response to your complaint, or the date you filed the complaint if no response was received. Sometimes some people will circumvent the AG office. They'll just go straight to circuit court. There are various reasons as to why. It could be that maybe they just really feel that an AG decision will just not be effective. There are a number of reasons why, but the state law does allow you just to go straight to circuit court within 60 days of the agency's response if that's what you want to do. However, that can be costly because you've got to pay the filing fee on a lot of that stuff. So that's why an AG decision is better first, because then that way you can gauge what the legal framework that they're relying on is. And sometimes the AG decision makes sense. Sometimes when we file complaints or we're trying to appeal an agency's response, we may not understand the other side that well. And sometimes that's where the Attorney General's decision is really powerful, because then it's like, oh, well, now I understand it. And what the AG decision will do, they'll also refer to other court cases, and that's how they are building their opinion that then can make more sense to you. Anytime you file a complaint, and anytime you receive an agency's response, or that you go through an appeals process, it is a news story. We're not just doing this as a process. Anytime you're working on something that has hefty weight, it is a news story. So if you file an open records request and it was denied, and then you and your news organization decide we're going to send an attorney, send the appeal to the Attorney General's office, then that becomes a news story. It's important that the public understands what's going on, because they need to see the fights that you're trying to take in making sure that the sun is shining. Okay, so that's why it's really important that any of these developments become a news story. So sunshine violations can be news. So we're going to go through an example here. of one that I've been through, and hopefully it will be able to cement better a lot of these concepts that we've discussed. So this is an actual case that occurred in Todd County. In October of 2006, the interim superintendent at that time, Bruce Gray, he fires the principal of Todd County Middle School, James Kenneth Killebrew, for what was called inappropriate actions. That was the only reason given. But there's not a whole lot we can do at that point because at that time, he is still, we're still going through what's called tribunal hearings. So the case is not closed yet. So tribunal hearings were scheduled in November, but then they were later canceled. And the reason why they were canceled was because in December of that year, the matter was settled by the board. I received that piece of information and I thought, why was it settled? So we were starting to already work on some things. But by February of 2007, we noticed in the order of the treasurer a $27,000 check had been cut to Mr. Killebrew in the form of a resolution agreement, what they called it, when it boiled down to that was the settlement payment. Well, now that the whole case has been settled, now we need to know what the specifics were. Why was a middle school principal dismissed? And then why were we paying him? Why was the district paying him $27,000? So we filed an open records request. It was denied because that did not sit well with us, and we knew we could get that record and that record was that should be afforded to us. We filed an open records appeal with the state attorney general's office. In April of 2007, the Attorney General Office concurs with the Todd County standard. Because, like I said, the Attorney General's opinion carries the full effect and weight of state law, the district opted to appeal the ruling of the Attorney General. So when they did that, they filed a lawsuit in Circuit Court of Todd County that named the Todd County standard as a defendant. Hearings were scheduled in circuit court and they got postponed. It went on for various reasons. And one of the reasons why was because there were people mentioned in this particular case that the judge felt he wanted to make sure he's protecting their privacy. That bothered me a little bit because to me, school employees, and this all dealt with individuals who were employed by the school system. So this dealt with employees who were public employees. So I didn't feel like they really needed that much protection, but we didn't really understand why. We had heard some rumors and we were told various things, but it was stuff that we could not corroborate and we could not really have any evidence of. But we had an idea still. So we just let the whole case run through its course. And in January 2010, there was a hearing at that time in which the judge wanted to go ahead and get this settled. And he said he was inclined to side with the paper, so that way the records would be given to us. January 22nd, 2010, his ruling came down officially and it ended the 3-year legal battle that we had with the Todd County Board of Education. However, so even though we had the judge's ruling coming down in mid-January 2010, it wasn't until March 3rd, almost 2 months later, that we finally got a copy of the settlement, what was contained in the settlement, and all the other corresponding materials related to this case. So you're probably wondering, so why was Mr. Killebrew fired? He was fired for sexual harassment, for intimidating female employees, and then for discriminating against 5 female school employees, all because they would not deliver sexual favors to the school board, to the school principal at that time. It ended up being kind of what I would call just a gross case, but it was really interesting, and it did make a great news story. It did win an investigative piece by the Kentucky Press Association for our fight in this. And it's still a case that many sunshine scholars, if you will, talk about because it went on and on when it was obvious that record was open to the public. But there was a reason why the school board wanted to keep this closed. And the big reason why is because of the sex factor there. So you're probably wondering, gosh, do I have to really know all this? Yeah, you do. You will have to know everything about the sunshine laws. However, there is an app that can help you. To download the app, you go to kypress.com/FOI. And you do that in your phone's internet browser, whichever one you use. And then when that opens, if you have an iPhone, you add to home screen and it will download to your home screen for you. It really looks like an app, it feels like an app, and it acts like an app. So it helps you on the job. When you are covering a meeting, and if you know that something's not right, you can pull it up immediately and be able to stand up and say something. We will take questions at another time, but that concludes this talk on the sunshine laws for regarding Kentucky's open meetings and open records laws. Thank you for your attention.